Very happy to have Dr. Alka with us in this session. She's a professor at Campus Law Center, DU. I think everybody can hear me. Yeah. And she has a PhD in copyright law from the University of Delhi. She's figured in the top 100 powerful women in law, and the list is released by the World IP Forum in year 2017. Dr. Alka has delivered lectures at various prestigious institutions and universities like the George Washington University, US, University of Edinburgh, UK, ESCP, Paris, Europe, Swiss Institute of Comparative Law, Switzerland, the Indian High Commission, London, Indian Law Institute, Federation of Indian Chambers of Commerce and Industry, and various judicial, police, and custom academies throughout the world. So currently she teaches intellectual property, administrative law, and jurisprudence. So it's a very good opportunity to ask as many questions or perspective you can from Dr. Alka, because she is so multidimensional, and in today's online times, I think it is very, very relevant copyright. Academicians are very concerned about the materials and the resources they are using. And thank you, Dr. Alka, for sparing your Sunday. Over to you.
Good morning, everyone. I am audible to all of you. Am I
yes,
audible?
you're audible. Yeah, you're audible.
All right.
And visible also.
Thank you. Thank you, Dr. Vinita. And thanks to all the participants. In fact, they're sitting for me, listening to me on a Sunday.
Yeah.
So my topic for today, as has been given to you, is it's copyright and management. That is why I've changed intellectual property and management to copyright and its management. What I proceed to do is, if anyone has a question in between, you can ask me. But what I plan to do is, I will first tell you what is copyright law, and then come down to the remedies which are available, and then also talk about how is copyright different from plagiarism. Because nowadays the basic problem is of plagiarism. People say that we write something and it's referred to as plagiarism by our institution. So what is the difference between these two things? That is what I'm basically going to deal with. So copyright law, if you see, it is basically there is a Copyright Act 1957. There are certain principles, general principles, which govern the copyright law. I would not be going deeply into the sections because I don't think all are law people. So some of you may not be the law people. So therefore, I would try to make it as simple as possible. First of all, I've given, if my presentation is visible to all of you, that it is a statutory right, which means that for anything, for any violation, or even whether we have a right or not, we will have to resort to Copyright Act 1957. Secondly, how does copyright come into existence? And for this, you don't require any kind of a registration. Like I think the session before me was with respect to patents, and you have to file an application, there's an examination, publication, and so on and so forth. And then only when you're granted a patent are you called a patentee. But whereas copyright is concerned, the moment your work is created, copyright comes into existence. One goes and files for registration of copyright only as a matter of prima facie evidence. So there is no need for registration, but people register so that there is a prima facie evidence to show that you are the copyright owner. The entire Copyright Act, you will find, it is based upon balancing system. Balancing, as you must have done under patents, you have compulsory licensing. That means it is the people's right versus the private right of the creator. Similarly, under Copyright Act, we have the right of the copyright owner, right of the author. With respect to, on the other hand, is the public. Once I publish my work, once I give my work to public, then public has a right to access that work. This is what is referred to as the Balancing Act. Then copyright, I will deal with all of these one by one. Copyright vests in original work. In patents, the requirement is novelty. Whereas in copyright, the requirement is originality. There is a difference between novelty and originality. And the difference is, novelty means something new, something which you did not know before, something which is non-obvious. And for non-obviousness, you're having experts to be present. Whereas when copyright law is concerned, it is not the presence of an expert which is required. It is a usual, that means an average spectator, an average reader who will find out whether the work is original or not. And for originality, the idea, the work is not necessarily to be new, meaning that it should not be known for the first time. So where does the copyright lie? Copyright does not vest in an idea, but copyright vests in the expression of an idea. Like, for example, if we have the idea of romance, if we have the idea of Saas Bahu, if these ideas were to be monopolized, then you will find out the entire Balaji productions on TV will come to an end and the entire Bollywood industry would come to an end. Because we can never work without romance in our films, and we can't work, I think, on serials without the Saas Bahu and the Devarani Jethani and all kinds of dramas which are present in the, the family dramas. So the ideas, the plots, the themes, the subject matter, there is no monopoly on that. There is no copyright on that. The copyright is only on the expression of an idea. That means the expression must emanate from the author, and then lies the originality. Copyright looks like a singular word, but it is a multiple of rights which are present under copyright. So that is why what I've written is copyright is a bundle of rights. If you look at copyright, you will find out that there are a number of bundles which are present under it. The first bundle is referred to as the exclusive economic rights. The second bundle is called moral rights. And the third bundle is called neighboring rights. If you look at the first bundle, which is exclusive economic rights, this basically means, and the next point that I've given to you is concurrent and split copyright. Taking both of them together, I would like to explain to you. Suppose I write a story. Now, on this story, I have a copyright means I have a right to make a film out of it. I can communicate it to public. I alone can translate it. I alone can make a sound recording of it. I alone can reproduce it. I alone can store it on any electronic means. So that means all these are my rights. If you want to make a film, you will have to take my authorization. And for my authorization, I'm going to ask money. If you want to translate, you will have to come to me for authorization. And for giving you that authorization, I'm going to charge money. So from one work, so many people can make further works, and all their further works would also be original, right? To repeat again, I write a story. I am the copyright owner of the story. I give my right to make a film, just the right to make a film to you. You make a film, you're the producer. You have a copyright on the film. I have a copyright on the story. Somebody wants to translate it. You make the translation. You have a copyright on the translation. I have a copyright on the story. So that single word copyright can be split up into a number of rights. And when they can be split up into a number of rights, we'll find concurrently there'll be a number of people who are the copyright owners. Somebody's microphone is on. Can you please mute it? Because that is causing disturbance.
Yeah, sure.
All right. The second thing which I wanted to say was, because as Dr. Vinita said that, online classes are on. So I thought my second slide should be the general propositions regarding the digital media. So we have these propositions which are governing the copyright law. It's applicable throughout the copyright law, that it's a statutory right, not mandatory to register. The moment you create it, you have a copyright on it. It vests in original works. That means it is only the expression which is copyrightable. The idea is not copyrightable. And it is I'm leaving idea, concept, expression that we don't require at the moment. It's a bundle of rights, meaning if I say I have a copyright on my story, I have a number of rights which are present in it. They all belong to me. Now, coming to the general propositions regarding the digital media. First of all, we all need to understand that internet is a communication technology. We are using internet at the moment for my lecture to be delivered to you and all of you sitting at your homes and listening to it. So we are all connected through this communication channel, which is the internet, right? Now, all type of information, whether it is print, whether it is sound, whether it is visual, any kind of a media, this thing, all these works, if they can be translated into a digital form, they can be transported via the internet, right? Now, so what is important here is, that copyright material sent over the internet or stored on web servers treated in the same manner as copyright material in other media. What this means is, as you apply copyright law on the print media, similarly, you apply copyright law on the digital media. So if we understand the print media, the same principles would be applicable to the digital media also. You know, sometimes people think that just because something is available on the internet, it is on public domain and we can do anything with it. That is not the situation. The material present on the web is in public domain means that at the click of a mouse, you can receive it. You can make use of it. But that does not mean that you don't require the permissions as you require under the print media. So therefore, just because I put something on the web does not mean that I have waived my copyright. I have not waived my copyright. All my copyright remains, whether it is in print or it is online or it is on the internet. This is very, very important to understand. Now going to the question of what is the subject matter of copyright, right? Now, as far as subject matter of copyright is concerned, there are basically 6 works on which copyright exists, and there are 2 more additions. I'll tell you, so it's totally 8 things on which copyright subsists. Firstly, it subsists in original literary, dramatic, musical, and artistic works. These are the 4 works which are always put together. Mostly they are put together. Literary, dramatic, musical, and artistic work. Whatever I write is referred to as a literary work. Whether I type it, or I print it, or I weave it, or I use my pen, that means something written is a literary work. Second thing which is important for literary work is that it is not basically, it is not the merit of the work which is important. Nobody will read and say, "Wah, bahut acha piece hai, you know, it's really good," and call it literary. Because this kind of language we use when we talk in English, the common man, what literary means. But under copyright law, literary means anything which is written down. So that would become a literary work. Dramatic is when you convert it into dialogues. Musical and artistic works, we all know artistic means any kind of a diagram, picture, painting, sculpture, all these are covered by the artistic works. The next thing is cinematograph films, that is audiovisual work, sound recordings, which is an audio work. These 6 category of works, first 4 prefixed by the word original. Cinematograph film is not called original because it's a derivative work, and sound recording is also a derivative work. But all these 6 works are covered by the exclusive economic rights of the copyright, where we say right to perform, right to communicate, right to translate, right to make a film, right to reproduce. All these are the rights of the person, the author, right? Now, next is broadcasts and performers. Broadcast, the rights of the broadcasting organizations, they also have certain rights, and rights of the performers, these are called neighboring rights. That's the second bundle. Remember, I told you there are 3 bundles. The first bundle is the exclusive economic right from where you can make money. The second is neighboring rights, meaning those people who help you, your neighbors, आपके पड़ोसी जो आपको help कर रहे हैं to communicate the work to public. And these are the broadcasting organizations and the performers. So they also have certain rights. And the third set of category of rights is called moral rights. I've not given it here, but moral rights basically has two rights, which is very, very important. The first one is called author's special right, which is right to paternity. Paternity means that you are, we always use these, we don't use gender neutral terms still in law. So paternity is always talking about who the father is. So the author would always be the father of the work. Even when the exclusive economic rights are assigned or exclusive economic rights come to an end, the right to paternity always vests with the author, right? The second one is, so that is why, this right to paternity is also called identification right or attribution right, meaning that whenever you pick up anything from anywhere while writing an article or a book or, any kind of a research paper, and you've taken something from somewhere, the author's special right, which is right to paternity, right to identity, or the attribution right comes into play, and you must always give a footnote and acknowledge from where you have taken it, right? The second right is called right to integrity. Right to integrity means that you can use someone's work, but you cannot use it in a manner that you distort another person's work or you mutilate his work, and this distortion or mutilation or modification results in bringing disrepute to the author concerned. So that means, one, whenever you pick up someone's work, you should always identify the source. And secondly, when you pick up someone's work, you cannot modify or distort it or adapt it in a manner that would be prejudicial to the reputation of the copyright owner. These two rights are very important, which is called author's special rights. Now the question is author always the owner of copyright? Now that is the fundamental rule. The fundamental rule is whosoever is the author is the owner of the copyright. We have section 17 in the Copyright Act, which says that the fundamental rule is that author is the owner of the copyright. But there are a number of situations where author is not the owner of the copyright. To give you an example, the biggest example is when you write for your organization. You are in contract of service with an organization, and as part of your job, you have to write something. So when as a part of your job you write something, you are the author, but you are not the copyright owner. The copyright vests with the institution or the organization for whom you are working, right? The organization or the institution with whom you are working. Now, as far as literary or dramatic work is concerned, you are the author of the work. For musical work, it is the composer. For artistic work, it is the artist. For films and sound recordings, it is the producer and not the director. For computer-generated works, it is the person who causes the work to be created. Now, whatever work you create, that is like your property. So copyright is like your property. So property can be assigned, it can be licensed, it can be relinquished, you can give it on will to anyone. So copyright means it's a property of yours which you can utilize for any of these purposes. Now the rights, I've just put the slide here. The kind of rights.
Professor,
yes.
Professor Alka, sorry for distracting.
Yes.
I have a doubt here.
I would prefer that people ask. Yes.
Yeah, so this is something related to what you have explained us now. We have a very famous music director, Raja. So he had the same problem and he went and sued on a singer who recently passed away, SPB, telling that it was his copyright that he made the songs and he cannot commercialize the songs being sung on stages. how far is this case correct on copyright? Either it is his copyright that it cannot be sung and made money off by selling tickets. Is it correct?
Sorry, I'm not very familiar with the facts of this. Somebody else also asked me. I think I should quickly go through the facts, but can you please repeat the facts to me?
Madam, now a music director, say for example, A.R. Rahman is composing the music and he is giving out an album. So the art who sung in the album, say for example, Shreya Ghoshal, if she is doing a stage performance and she is making money out of singing, so is it bannable? Like, does A.R. Rahman got the right? You're not supposed to sing it because it is my composition.
Actually, this is a. Can you wait for my answer to be given?
Yeah, madam. Just because very clearly explained us, telling that the organization becomes the copyright owner, not the person who's looking for it, and as it becomes in service. Thank you, madam. Just
I will just refer to this case just in a minute's time. So because it might become clear to you as I proceed with some of the questions. But please do remember, I have to answer this question.
Sure. Thank you.
All right. So these are the rights which are present of the copyright owner. All right. Coming to the copyright owner, there are two things. One is when you're in contract of service. That is when contract of service means there's a master servant relationship involved, and in a master servant relationship, it is the master who's the copyright owner, but the servant is just the author. That's one of the exceptions under section 17. The second exception is for commissioned works. There are certain works for which you pay a price and you get the work done. Like for example, when I go to the photographer, I pay money for getting my face clicked. Now there the photographer, according to this slide, I'll just have it here. According to this, photographer is an artist and artist is the author. But since I have paid money to get myself clicked, I will be the owner of the copyright. Right? And since I'm the owner of the copyright, many times what happens is we go to a photographer or we engage a photographer and he clicks your pictures and he puts your picture in his studio. Now, as a human being, we feel very happy. Wow, I look so nice. That's my picture is there on the wall. But in fact, yes. Somebody saying something? All right. But in fact, there is an infringement of my copyright because the author is the photographer, but I'm the owner of the copyright. And since I'm the owner of the copyright, you're putting it for public display. You will have to have my permission to put it for public display. Right? Now, cinematograph films or songs or music, this is a field which is treated differently under copyright law. And what happens is, I'll just take just a few minutes because, some of you, I do not know whether any one of you are from the, teach media or film studies also in your classes, and especially, when you're having these online classes. What happens is when there is any artist, lyricist, or a composer of music, there are various people working in a film. And when there are various people working in a film, what you find is that there is a lyricist who writes. Lyricist creates a literary work because he's writing the song. The composer of the music is the owner of the music, right? Now, and the one who sings is the performer. How it works in a film is all these people, they assign their rights to the producer of the cinematograph film. Now, producer of the cinematograph film gets all the rights. So for running of the film, none of them can say that you run in this theater and you don't run in that theater. It is our right. They lose all their rights once it is put it into the film, right? Now, but what happens is, suppose the producer of the film uses any part of the work for something else. Say, for example, he may just pick up a part of the film and give it to a person for an advertisement. Like, I don't know how many of you have heard this advertisement on our Pyar Hua, Ikrar Hua. I'm very bad at singing, so I'm not going to sing and tell you. But Pyar Hua, Ikrar Hua, there are two people walking under umbrella. That's the Nargis and Raj Kapoor song. And now there's an advertisement which is made on it, right? So when you do something like this, the producer of the film takes out a part of the scene and gives it to someone and makes money out of it. This money which he gets now after 2012, previously that was not the case. After 2012, he will have to share the profit with the lyricist and with the music composer, right? But all the other rights vest with the producer. So it depends. Now, suppose somebody has written songs as part of an organization for the organization under a contract of service, he cannot claim copyright in it. That's for sure. Whoever makes music as a part of the work for the organization would not have copyright in it. It would be the master. It would be the organizer who would have it, right? Now, going further, so we'll have your questions later. Going further, this is what is the rights of the copyright owners. As I said, there is a balance of interest which takes place. Now, for balancing of interest, there are three methodologies which are used in the Copyright Act. The first is the term of the copyright. The second is the licensing, that is compulsory licensing. And the third is called fair dealing. I will deal with fair dealing first rather than coming to this. Let me, all right, 1 second. Yes, this is what is fair dealing. I would like to take this up first because during, when I do this, maybe some of your answers, you might get answers to your questions. The right of reproduction, which the copyright owner has, I say, I am the author, I am the copyright owner, I have a right of reproduction of my work. This is subjected to a few exceptions and limitations. There are certain conventions under Copyright Act, and one of the basic convention is the Berne Convention, and then came TRIPS, which we have all heard about, and then in 1994 came WIPO Copyright Treaty. This was basically how the Berne Convention is to applicable in a digital media. Anyway, we can leave that, right? What is important is if you look at all these conventions, they are saying that it shall be a matter for the legislation in the countries. That means, let's say it is a matter for our country, India, to permit the reproduction of such works in certain special cases, provided such reproduction does not conflict with the normal exploitation of the work and does not unreasonably prejudice the legitimate interest of the author. What this basically means is that you can use my work. I have written something. You can use my work without taking permission from me. But the use of the work has to be in a manner that it should not become a competition for me. It should not affect my commercial exploitation of my work, and it should not also be unreasonable for me. So we see that there are certain exceptions which our Act allows. Look at this one. It says, continuing, that was the international convention. This is what the Indian Act is. And the Indian Act says certain acts not to be infringement of copyright. The first one is a fair dealing with any work for the purpose of private or personal use, including research. That means for your research, for your private or personal use, you can pick up any work, you can reproduce any work, you can keep things with you. No one is going to ask you, how did you do it? Why did you do it? You are a thief. No, you're not. Because the objective of the copyright law is not to stop the cultural or the literary growth in the country. So for the purposes of researchers, academia, we fall in the exception. We can reproduce the work. For criticism or review, somebody has written an article, somebody has written a book I need to criticize it. I need to review it. I will not be able to review a criticism unless and until I take certain paragraphs from there. Now, there are no, normally the questions which people ask me is how much work can we take? You know, coming to how much work you can take, there are no percentages which are given anywhere. This is always taken from fact to fact situation. Let me give you a fact and you give me an answer for it, right? The fact is that there is a book which consists of 400 pages. It's a fiction. And there is a report which consists of 400 pages. Now, from the fiction, you pick up 40 pages of the fiction, which is talking about, it is not the plot of the story, it is talking about nature, monuments, or something like that. And now you pick up 40 pages from the report. But these 40 pages of the report consist of the executive summary and the recommendations and the conclusions, right? Now, what the law says is that when you make a substantial copy of anyone's work, you need to take an authorization of that person. If you don't take an authorization, then there's an infringement of copyright which takes place. Now you tell me in both these cases, 40 out of 400, which means, what is the percentage? Some mathematician? 40 out of
10%.
10%. Now, for fiction, I've taken 10%, and from the report also I've taken 10%. That is the quantity. But from fiction, what I've done is I've taken, you know, about the nature and monuments and rivers, whatever has been mentioned there. I've taken that. But when it comes to a report, I've taken the executive summary, the suggestions, the conclusions. Do I make a substantial copy in both the cases, or do I make a substantial copy in one of the cases? Yes, anyone? Would someone like to give an answer?
I think in second case, we are going to make substantial copy as compared to, previous situation. Because
So,
maybe in previous situation, we have referred that data just to make a report, or we are giving reviews. Or in second case, because we are making the executive summaries, certain recommendations, suggestions. So it may be copy of somebody else who have earlier given these all things.
so what you're saying is in case of report, we make a substantial copy, though we are picking up only 40 pages. Is that what your answer is?
I think it may be because to make that report, we need to refer that data.
No. I'm not saying whether you need that data or not. My simple question is that you have picked up 40 pages of the report, which is consisting of the executive summary, some suggestions and conclusions, right? Is that making a substantial copy?
No, I don't think so.
And what is in the case of the novel?
In case of novel, maybe that person has given a copyright to someone else because he's getting the
Please don't.
commercialization for that.
That is where everybody makes a mistake. Don't add ifs and buts. I have given you a few facts, right?
Yes.
Out of those facts, you will have to tell me what it means. I'll again explain to you. In case of, economic rights basically means, or the copyright basically means that if I have written something, you have to take my permission. Simple as that, right? But there is a provision for fair dealing. And what fair dealing says is, that is acts not amounting to infringement. What they're saying is, fair dealing with any work for the purposes of private or personal use, including research, criticism or review, reporting of current events. Let me already finish with all these. Reporting of current events and current affairs, including the reporting of a lecture delivered in public. Second, transient or incidental storage of a work or performance purely in the technical process of electronic transmission. Like, for example, I don't know if there's anyone of my age sitting in the group, you will remember. I will come to the answer. You'll remember that, when MTNL started internet, they said for downloading, you can only download this much. And what happened with all of us, mostly, I know of many people, they complained that suddenly the bill shot up and they filed complaints to the MTNL saying that we have not downloaded anything. We were only browsing through the internet. Now, without realizing that when you browse through the internet, a copy of it is made on your hard disk. And when a copy of it is made on your hard disk, that is what is referred to as downloading, and money has been basically charged for it. Now, when it was downloaded on your hard disk, that was a part of the technology. When it is downloaded means you're making a copy of it. Now, making a copy is again done by the hard disk. You know, this B, what I've given, was added only in 2012 to the Act, and why it was added for this purpose only. So you can be charged that there is an infringement of copyright. You have made a copy of the work, but you've not taken the permission of the author, because you've totally, you know, the entire copy is made on your hard disk. So there's right of reproduction getting affected of the copyright owner. So in order to do away with such problems, this B was added, that is transient or incidental storage of a work that would not amount to infringement. Let's see more examples and then I'll come to you. It says, the reproduction of any work by a teacher or a pupil in the course of instruction. Now, when I'm teaching you something, or my students I'm teaching something, I can reproduce anything. It may be, but it must be for that particular educational purpose, right? The reproduction of any work by a teacher or a pupil in the course of instruction, or as a part of the questions to be answered in an examination, or in answers to such questions. Now, this is where, you know, the Rameshwari photocopy shop case, if you've all heard of, fell. It says, reproduction of any work by a teacher or a pupil in the course of instruction. These three words, in the course of instruction. The question is, when does in the course of instruction begin? The answer given by the court was, the court said that when, like for example, I have come here to teach you, it is not only between 12 to 1:30. I prepared for this lecture prior to 12 o'clock. And that's what all of you do. You know, to stand for 1 hour, especially if we go back to our initial years of teaching, to stand in a class for 1 hour, one has to study for, I don't know, innumerable number of hours so that we could stand for that 1 hour in the class. Because there may be one person who may be asking a question, but we have to be ready for that answer. So the court said, in the course of instruction means from the beginning of the semester to the end of the semester, because you begin to prepare. So when you give anything to the student for the purposes of the examination, until the examination, you can reproduce any of the works without taking the permission of the author. That is the kind of exception which has been created for the teachers. So it says the reproduction of any work by a teacher or a pupil in the course of instruction, right? Next, storing of a work in any medium by electronic means by non-commercial public library. Delhi University, non-commercial public library, we can store the work in electronic medium, but provided we have a non-digital copy. That means we must have a hard copy, then we can make backup of it. Nobody can say that we reproduce the work and we have infringed the copyright of someone. Right? Similarly, so there are a few of such exceptions which have been given, and another one which was added in 2012 was persons with disability. This is basically more for those who cannot, they cannot visually see. So for their purposes, when you make a copy of it, then you don't have to take the permission of the author. Right? So what have I done? Given you all these things showing that for a reproduction, for making a copy, you have to take the permission of the author. If you make a substantial copy, you have to take the permission of the author. But if you don't make a substantial copy and it falls under any of these categories that I've given, then it would not amount to infringement. So now I will repeat my question, which I had given you before. In a novel, when you pick up 40 pages, which is not the story of the novel, that means it is not a substantial copy. Substantial copy would be one where you're picking up the story. In the report, what is important is, in any report, the most important thing is, sometimes what happens when a report comes in our hand, we don't go through all the pages. The pages that we look at is the executive summary of the report, the suggestions made, and the conclusions of the report. That is what is the crux. That is what is the substance. So if you pick that up and you put it in your report, that would amount to copyright infringement, right? So what you're doing is, the question probably that you have is, you need that data for your purpose. Yes, you make use of that data. Nobody's saying don't make use of that data. But then you can't pick up the entire report and then you build up on it. There may be one suggestion or two suggestions which you think, and then if you give, if you attribute, that means if you acknowledge from where you have taken it, then there is no problem. So what is fair dealing is, there are various tests which are applied. If you're taking short excerpts and giving long comments, that would not amount to infringement. But if you take long excerpts and give short comments, that would amount to infringing of copyright. Am I making myself clear? Whosoever was speaking saying that report is not a substantial copy, you cannot take the executive summary and the suggestions and the conclusions as they are, because that is what is the core of the report. And when you take the core of the report, that amounts to substantial copying. You will have to take the permission of the author in that case. But if you pick up a few things, in the sense you agree with some, suppose even if you pick up all recommendations, but what you're doing is you're reviewing the report. Let's take an example. I review that report. Now, when I review that report, I will have to take each and every suggestion and give a comment on it. So everything would be taken up by me, but my comment has to be an analysis of what that excerpt is. If I do that, I don't need the permission of the author. Am I making myself clear? Or still somebody has a question?
It's very clear, Dr. Alka. Very clear. And
Okay.
Absolutely at the level required.
All right. Thank you so much. So then I'll proceed further. Rather than coming to judicial remedies first, let me come to, one second. I'm, bad at this. I thought I'll first take up what is, wait a minute. I'll first take up what is the difference between plagiarism and copyright, right? Because that is where problem lies. This is what I'd given you till now is talking about copyright, where copyright exists, what are the rights under the copyright, and when violation takes place. Violation, simple cases, you have to take the permission of the person concerned. If you don't take the permission, then it amounts to violation, or what we refer to as infringement of copyright. But under section 52, there are a number of provisions which are given where you don't need to take the permission of the author. So you will have to go to section 52 to find out whether your case falls under that or not. Now coming to copyright and plagiarism. Plagiarism is a common English word and copyright is a legal word. That's the first and the most important difference between the two things. Plagiarism is taking someone's work and passing it off as your own. It's basically a violation of moral, ethical, or organizational norms. What happens is organizations, sorry, that's wrong. Organizations enforce plagiarism and copyright is enforced by the court. That's what this basically means is, whenever we are talking about copyright infringement, we take recourse to legal methodology. That means we'll have to either file a civil suit or to file a criminal suit. But when it comes to plagiarism, then it depends what kind of a policy has your organization given. Okay. Now, if I pick up an idea of somebody, that would not amount to copyright infringement. As I said initially, there is no copyright on an idea, but there is a copyright on the expression of an idea. So the same idea written by 10 people differently in their own language, each one of them will have a copyright in their work. Similarities are bound to occur, but that does not mean that you have violated anybody's copyright. Okay. If I have created a work, I'm the owner of that work, and I can keep on using it and reusing it as and when I want. But when it comes to plagiarism, there's a concept of self-plagiarism which has been introduced by the academic institutions. What this basically means is that I cannot use my own work, right? If I use it, I have to mention that my such and such work was published at such and such place. There has to be an attribution which has to be given to me. If I don't give that attribution to me, then I have committed a theft against myself. This is not the case in copyright infringement. First thing which I said was, if you pick up someone's idea, there is no copyright infringement. But if you pick up someone's idea, that may be plagiarism. When you paraphrase something, that is not copyright infringement. But when you paraphrase something, that is plagiarism. Unless and until you mention that these few lines, I mean, whatever, 3, 4, 5, 10, whatever you've done, there has to be an attribution which has to be given to the person concerned that the idea was his and I am now putting it here. Okay, let's take a few examples of acts where permission of author or owner is required or not required. Right? You can quote paragraphs from someone's work with proper attribution. You can do it for report also. You can say that these were the suggestions made by such and such report. But that would amount to no infringement if on those recommendations you comment, you make an analysis of it, you make a review of it. You don't pass those recommendations as your recommendations. Then there is a problem, right? You can paraphrase or pick up ideas, but again with proper attribution. While teaching, you can show a film or a song to your students. In the course of teaching, you don't require anybody's permission. You can use any drawing, any article, any depiction, whether visual or audio or print, anything can be used by you, provided it is used for the purposes of teaching. It has an educational purpose, otherwise that would not be permissible, right? Now you can't, I'm teaching law and I can't show the entire Three Idiots movie to all of you saying that I just want to give you an idea about friendship. Right? No, that's not a part of my course. So since it's not a part of my course, I cannot show it to you. But yes, if I need to show to you with regard to I'm a person which is dealing with media laws or with the media, then I can, show to you the direction of it. I can show you the entire film and ask you to write a critique on it or analyze the movie or analyze the characters. That is something that can be done. Okay. Links. Many times people ask, can we give link to anyone? Would that amount to copyright infringement? Giving of a link is no copyright infringement because links are addresses. But along with the link, if you give the article yourself, that would amount to a copyright infringement because then what you do is you reproduce the work. Giving of a link means you're only redirecting the person to some place. You're telling someone, alright, go to Saket. go to defense colony. That is what you're doing. So what the person goes and does in Saket and defense colony is none of your problems. You're only giving a direction. But when along with the link, you also give what is given in the link, that would amount to copyright infringement, right? You can make copies of work in any accessible format for persons with disability. There are people, they're visually disabled, they can't read something. So when I record it for a visually impaired person, then this reproduction done by me, I don't require the permission of the author. I can do it provided I'm doing it for some person's benefit, right? For writing reviews, you can pick up paragraphs, scenes and songs, but then short excerpts, longer comments. If you've written a book, see, this is a very, this happens with a lot of people, and I'm also one of them. Because we are not business people. You know, what we do is, I remember when I wrote my first book, Macmillan people had come to me and said that we are starting a legal division. So we want to write a book on copyright law. So why don't you write for us, right? I wrote the book and I assigned my copyright to them. Once I assigned my copyright to Macmillan, then you and I, we are standing in the same position with respect to that book. Because the copyright doesn't vest in me, the copyright doesn't vest in you, but the copyright vests with the publisher. That means from my own work, I cannot pick up, substantial picking up I cannot do, because I am the author, but I am not the copyright owner. So when you enter into agreements with the publishers, I know we don't have choices because there are standard form contracts that they come up with, but you should at least read the contract. That is very important, because many times what happens is we don't read. You know, recently there was someone from some college who came to me. She has written a number of books. I said, you show your contract to me. And you know, in the contract, the upper portion of the contract says, the right of translation belongs to the publisher. The very next line says, notwithstanding anything above, the right of translation vests with the author. Right? Now just one below the other, one above the other, and you find out that they're contradictory. Since they're contradictory, you will not win the case in the court. The court will say this doesn't make any sense. You have signed it, but in one line you are saying the right belongs to the publisher, and in the other sentence you're saying right belongs to you. So to whom does the right belong? The contract is not clear, so this is not applicable. So what may happen is that you may say that since all the rights are assigned to the publisher, it is the publisher only who has the right. It depends how the court is going to read it. So kindly read the contract whenever you write for someone, because what you're assigning and what you are not assigning is very, very important. Many times what happens is you say that I assign the copyright for the purposes of publishing in the territory of India. Now, what the publisher does is he publishes the book and sells it outside India. That would amount to infringement of your copyright. Right? Because what you had, the right that you had given to him was publication only in India. The right to publish abroad still vests with you. So it is very important to understand that copyright is a singular word with a number of rights in it. So therefore, what have you assigned? You can assign one right, you can assign two rights, you can assign all the rights. It all depends. Let's take a few examples of plagiarism. Plagiarism of words, meaning you pick up the words as they are, that would amount to copyright infringement. Plagiarism of structure, concept, that depends on a number of things. It is what kind of work are you talking about? Because fiction would be different from non-fiction. Scientific work would be different from mathematical work, because you know, in mathematical equations, for example, you don't have a copyright. Those algorithms and equations, there is no copyright which is vested, because Berne Convention says so. So it may be, you may say this is unethical, it is immoral, it's not fair, whatever you may say. But since copyright is a statutory right following the Berne Convention on equations, on mathematical concepts, on algorithms, there is no copyright which is present. But how you present it, writing of an article, on that you will have a copyright, right? Plagiarism of ideas. It may be plagiarism, but there is no copyright infringement. Plagiarism of authorship. आप किसी की किताब उठा के as such छाप दो और लिखो, you just नीचे छोटा सा लिख दो, the author is so and so. That is not fair. Since it is not fair, therefore it is infringement, right? Self-plagiarism is not copyright infringement, but it is something which has been introduced by the organizations. So let's come down to the remedies now, and then I will stop so that if anybody wants to ask a question, you can. I'll go back to Ilyaraja question also. Where is it? Where are the? All right. Yes. Now, as far as copyright infringement is concerned, there are judicial remedies available. You can file a civil suit and you can file a criminal suit. Both can simultaneously be filed. Okay. So please, that is why copyright infringement, people don't take it up seriously. There can be criminal proceedings also. That means one can be imprisoned and there can be a fine which can be imposed. When you file a civil suit, the remedies which are given are that injunctions are issued, or damages, you have to pay damages, or you account for profits showing what profit did you make. So all that profit will have to be given to the owner of the copyright. I don't know whether this is really needed or not, but I will tell you, since we're talking about copyright law, injunctions, they're very important. There are three kinds of injunctions which are getting more and more important today. One is called Anton Pillar order. Let me straight away come to it. Anton Pillar order means I know someone is infringing my copyright. Like, for example, you go to that Daryaganj, so many pirated books are being sold. You go to Nehru Place, so many pirated, CDs and computer programs, software is being sold. Pirated means, the meaning of pirated is that you have not taken the permission of the author and you're reproducing the work. So reproduction of work without the permission of the author is referred to as infringement of copyright, and in loose terms it is called piracy. Piracy means infringement of copyright, right? Now what happens, we know that there is a piracy taking place. What I'll do is I'll go to the court and take an Anton Pillar order. This Anton Pillar order basically is that I file a suit in the court. The court will appoint a court commissioner. This court, it's like, in simple language, it is raid. Raid मारते हैं ना, जिसके घर में raid पड़ी है उसको नहीं पता कि raid पड़ने वाली है. So here also, the defendant doesn't know that this Anton Pillar order is going to be exercised against him. I am the copyright owner. I go to the court. I take the Anton Pillar order. There are court commissioners. I take them and we go to those particular premises and we find out what is being infringed, what is not being infringed. And thereafter, what will happen is I will have the power to seize and seal all the infringing evidence that is present in the infringer's premises. This remedy sends a very, very strong signal to the infringer, because infringer doesn't know कि उसके घर पर raid पड़ने वाली है. The second thing which is important is John Doe or roving or Ashok Kumar orders. Why we have John Doe or Jane Doe is basically because it's a very common name, और हमारे यहाँ पे इसको translate कर दिया to Ashok Kumar order because Ashok is a very common name. This happens when we do not know who is infringing our copyright. There we know that infringement is taking place, but who is infringing? I do not know the person concerned. So is it that I can't file a case? I'll go to the court and I'll take an order in my hand which is called a John Doe order. इस order के साथ I can commit a raid to some place जहाँ पर मुझे पता चलता है कि infringement हो रही है. I get to know that infringement is taking place. So I will go there and I will tell them that, look, I have this order, you can't continue with this. This is an order which is normally taken a week before the release of a movie. Normally, it started with I think Lagan, or I don't remember which movie. Lagan people took it. Singham was, I think, the first one to take the John Doe order. Now what happens is, the film cannot be showed by anyone except the producer. He alone has the right to exhibit the film. If anybody else does it, if the producer has the John Doe order in his hand, he can stop others from showing the film by whatever methodology, right? The third one, which is becoming very, very important nowadays, is, this is basically what was happening was, how it started was that you get an injunction for things not to be put up on a particular website. So the court said that, all right, this URL has to be taken down. But then there are a number of URLs in a particular website. So then what happened, the court started saying that the entire, what we refer to as the rogue websites, they have to be brought down. Now, people are smart enough. If there is an abc.com that is brought down, immediately what you do is you have an abc1.com and the same material is put up there. That means the person will again have to go to the court and get an injunction against abc1.com. You get an injunction there, and then the person starts abc2.com. So will you keep on going to the court? So the court said, no, this is not fair. So what we'll do is we'll give a dynamic injunction. Dynamic injunction is applicable not only to that particular website, but to the mirror websites that are being created, right? So the injunction, you have only one injunction in your hand, which is applicable to that particular rogue site and to all the mirror websites which will come into existence. The only thing that you need to do is you will have to bring it to the notice of the registrar that there is a mirror website which has come up, and that's about all. And the injunction is redirected there. So then there are damages. You have the compensatory damages, punitive damages. Then criminal remedies are, on first conviction, 6 months is the mandatory minimum, which can go up to 3 years, and 50,000 rupees fine or 2 lakhs fine. And if this, for the same offense, twice you have been picked up, then minimum mandatory raises to 1 year, and minimum mandatory fine goes up to 1 lakh. So I think with this I would stop, and now I would like you to ask any questions. Yes, ma'am, whosoever was asking me with regard to Ilyaraja, I don't know whether your question has been answered or not. But what I can say is that if there is a composer of the music, the composer of the music has the copyright. The lyricist has the copyright. But the singer does not have a copyright. Singer only has a performance right. But for everything, permissions have to be taken from the required person. Yes, I can have questions now. Thank you so much.
Okay, Dr. Alka, should okay.
Ma'am Shailaja here.
Yes.
In continuation with what answer just you gave
Can you
regarding
speak up?
Ilyaraja case, when a particular singer sings entire song with all the music band which is identical with the music composer and even the lyrics, so does it mean that the permission has to be sought with every person who has done a piece of contribution to make that particular song?
That's a very good question.
Thank you, ma'am.
What happens is it is very difficult for a single person to administer his right, because see, your property of house is something which is under your control and you don't let people get in. But copyright is something which you create and you want people to get in. Unless and until it gets communicated to people, you don't like it. It's just the opposite. For ownership of a house, you don't want an entry, but for ownership of a book, you want everybody to enter it. Only then you feel satisfied, otherwise you don't feel satisfied. That's one thing. So it's very, very difficult to administer your copyright. So for this purpose, there are copyright societies. So what we do is, like for example, there is IPRS, Indian Performing Rights Society. There's ISRA, for singers there is a society. You simply have to file an application to that society to take permission. They will give you a permission for charging. They'll charge you some amount of fee, and things can be done. But yes, what you are asking, one, that is the answer to your question, that you don't have to go to everyone. You will have to know who is the copyright society dealing with such and such matter. At the moment, there is IPRS, which is called Indian Performing Rights Society. You can just go to their website. All the details are given there. There is ISRA, which is for singers, for performances. That's also a copyright society. And for reprography, there is this RRO, which is called IRRO, Indian Reprographic Rights Organization. So they are the ones who are administering rights on your behalf. Now coming to the second part, which you've not asked, what happens is when you're singing a song sung by someone and you're having your own musicians, this is what is referred to as cover version. There's a special provision under the Copyright Act. It's called 31C, I think, either C or D, which is talking about statutory license for cover versions. If there is a song and 5 years have lapsed, then what you can do is you can make a cover version, means a different singer, different musicians, without taking anyone's permission. But there are certain conditions. The conditions are you have to, whatever label that you make for that sound recording, those labels will have to be given in advance to the producer of the sound recording. And you have to produce minimum of 50,000 copies per year. And to those 50,000 copies, a part of the royalty has to be shared with the producer of the sound recording. But if it's a language which is not so widely used, then the registrar can minimize the number, can reduce the number. Going again to what you've asked, what is happening nowadays is many people are on the YouTube. What they do is they sing songs with their own musicians or music. The same lyrics, no change, nothing. Now, YouTube has a policy. So what they do is they inform the owner of the copyright, because they have this copyright content system and verification systems, and they have their IPR policy. It is told to the owner that this is what is happening, or the owner himself may complain. Now what happens, the person who's sung has got 3 alternatives, 2 or 3 alternatives. The first alternative is he removes his song from, he downloads, he removes the uploading, what he had done. The second is he says, no, I'm right to do it. He may contest the matter in the court. And the third one, which is happening very common nowadays, is the owner feels happy that his work is being communicated to people, but he says, all right, you sing, but you share the profit with me. Whatever money that you get out of ads, you will have to share it with the owner of the work. This is how the things happen. I hope I've answered your question.
Yes, ma'am. Thank you so much.
All right. Yes, anyone else? No questions?
Ma'am, I want to ask one question. This is regarding the UGC Care List journal. Sometimes they shown the list, these are the pirated journal, like they are using same ISBN number, same name even they are using, and even publisher name, they are just adding 1 or 2% or language, they are just adding, like maybe one journal is in only English. So they are using all details, then other will be in English and Hindi both. So in that particular case, when as a, that authors, we write paper for those things. So we don't know that these are the pirated things or these are the copy which has been made for these all journals. So who will be at flaws in this condition?
You see, if there is a journal which is given by UGC saying that this is pirated, then you know about it, because they on their website they put it and they presume, actually this has created a lot of problem, I understand. And all of us are sailing in the same boat. There's something which is called contributory liability. Contributory liability means that if you get to know from the UGC site that this is a pirated journal or having the same ISBN, so you should not publish your journals here. So you're expected to know about it and not to do anything of that sort. But even if you, even if you publish in a pirated journal, what does a pirated journal mean? They have done something wrong, right? They have taken somebody's ISBN number, but you have given it your article for publication there. What wrong have you done? Nothing. Your work is getting published. The only thing that may happen is that you will not get those, I don't want to add any prefix to it, but whatever you refer to as your API scores, you will not get an API score, but you have not committed an offense because it is your work and you have given it for publication to someone. You are reproducing it. You've not done anything wrong.
Okay.
Is that
Can
clear?
I, am
Yes,
I
ma'am.
audible?
In this case,
Yes, yes, you're
ma'am,
audible.
in this
Yeah. I
case,
wanted to ask
like,
something like
One second.
in the light of section 57 that you have mentioned with regard to right of paternity and right of integrity.
Yes.
Now in a master service relationship that you had mentioned during the present, the PPTs that we make for the universities during the classroom session, is the ownership lies with the university or with us?
I know
Second,
this is,
if I use this PPT in some other universities MDP, does the university also has a right or the right remains with me?
yes, that is a very difficult question, and it is coming up mostly in private institutions. In an institution like Delhi University, nobody, I would rather use the language, dare say such a thing to us. But what is happening is, yes, I'll come back to that. See, the question is, what does teaching mean? You are teaching as a part of the university, right? Now, because when we were teaching physically, we were showing those PPTs, actually, they've taken up this question in my book. On the lecture, let me tell you a few things. You will have to, but have patience with me because I still have.
Absolutely, this is very valid. So I wanted to ask you, should we go back to the old whiteboard system teaching?
No. So listen to me. First of all, teaching to a private audience, there is no copyright in it. Meaning thereby that when I teach in my class, I'm lecturing in my class. I'll come to online in a minute. I'm lecturing, or even this is applicable to online. When I lecture to my class, it's a private audience. And on that, I do not have a copyright. But I do have a performer's right. Copyright meaning if you're sitting and writing, taking notes. It has happened in our law faculty when we teach. There was a person who was very fast in taking notes. He was taking verbatim notes and he publishes those notes. I cannot do a thing about it under the Copyright Act because I don't have a copyright on my lecture. But I have a performer's right. Performer's right means you cannot audio record my lecture or you cannot visually record my lecture. You will have to take my permission. Like, for example, we don't bother about these things. Now, I see that recording is taking place.
Okay, now can I intervene
One
here?
second, no, you'll have to give me a
Okay,
minute.
okay, done.
So this recording is taking place. That is amounting to copyright infringement of Alka Chawla, and Vinitaji is not taken by permission. Okay, but I don't bother about it, and nor do most of the academicians bother. But it is a copyright infringement because if now it will become a copyright infringement, one by recording, and secondly, if you show this to the next set of audience. Coming to our teaching, when I'm teaching and making a PPT, teaching is something which I'm doing for the university, but it all depends upon me how innovative I can be, right? So as a part of that innovation, I use that PPT. There can be two arguments if you go to the court, so nothing is clear at the moment. The organization can say it belongs to me, And you can also say, no, it belongs to me and I can use it anywhere. And I think you can go ahead and use it anywhere, your PPT, because that's the work which you do in the hours which are available to you when you're not a part of the servant of that particular organization. What you're doing at that point of time is what is your teaching. But when I'm sitting at home and making my PPTs, though I'm doing it for teaching purposes, but I'm doing it in my own free time. And it depends how much of a PPT can I make. That is why when teachers ask me, many times I tell them, if you don't want to share your notes, you make a very sketchy PPT, because there's a mandate on you to make a PPT. So you make a sketchy PPT. But if you don't bother, तो जैसे कई लोग हैं जो कहते हैं नॉलेज बांटने से बढ़ती है, आप डिटेल में PPT बना दीजिए. So this is a gray area, but I think you can use your PPT at the moment and say it is a fair deal if the problem arises.
Good afternoon, ma'am.
Yes.
Ma'am, if a university asks their faculty members to record their lecture so that
Yes.
it can be uploaded on website,
Yes.
so is it like whose right it is?
Same thing.
Sometimes pressurize faculty members to upload it to record the lecture.
I know it's happening nowadays. My daughter-in-law was facing the same problem because she also works for a private organization, and you have to perforce give your recording to them. It is a performer's right in the sense that they take what they can do is they will take your permission, and you will have to grant permission to them. This is all Matsya Nyaya, Chanakya ka, big fish eats the small fish. So you can't say no to them. You will have to say yes, and they can use the recording for whatever purpose. But you can say no to your recording if you have the courage.
Thank you so much, ma'am.
And what about the
Doctor,
cross-border infringement? When I'm taking lecture cross-border, then how do I protect myself?
Protection in what sense are you talking about?
Same, the replication of my lectures in the cross-border issues in different countries. Because today we give lectures all over the world. Now replication, yes. I don't give consent to anybody like you are recording. So I don't give consent to anybody to forward my recording to the participants. That is the first condition that I lay, only then I will come. I don't let universities record. In the cross-border section, how do I protect myself?
It is very difficult. It has happened in Ramdev's case recently. I think the judgment came where it was for commercialization of projects. And they said that, if you upload something here in India, then you can go to the court and get the entire thing down. But the uploading has to be. So if you're recording here in India, you can go to the court and following the Ramdev, the court can ask Google, for example, pull it down. Whichever platform you're using or whichever platform the defendants are using, they can pull it down.
Can you give reference of this judgment and will it be covered under GATS?
Yeah. So what you do is, I don't have the citation now. So what you can do is you just put Ramdev judgment, copyright issues, it'll come. Or you can even mention Ramdev globally pulling down the websites. You just put it, well, it'll come.
Thanks a lot. Thanks, Etan. You've been wonderful.
Yeah. I mean, the most relevant session, especially in these lean times. Dr. Alka, I also have a question, and it's regarding the research paper. I don't know how to put it, but often when we are quoting some other authors' research paper, there are certain in-text citations which we like. Yeah. Because say author A says, so and so have given their these views or perspective on a particular theme. I want the entire message to be in my paper. So should I go one by one looking at all the literature he has quoted, or is there a way I say so and so author A has quoted these 4 authors on this perspective, and this is what I'm quoting in my literature? What is the right way?
No, you can put it in the footnote, saying that such and such author has used all these authors, and you've basically taken it from author A only.
Okay.
So it shows that you've not gone through the original readings.
Okay.
So that can be done.
Okay, there's another question. It says, the legal framework for international copyright violation. What is the legal framework for international copyright violation? Example, Indian writers' copyrights are violated in UK. How to approach and what is approximate charges and time frame for litigation process? There is no
time and charges, I can't say.
Yeah.
It depends, right? And as far as international violation is concerned, there is an organization called WIPO, World Intellectual Property Organization. They have a mediation and a center, arbitration center. So you can just write to them, and this is how cases are taken up. So go to WIPO site and look for the litigation there and make a complaint there.
There was one
Hello,
question.
ma'am. With regards to that UGC care list journal only,
Yes.
suppose like I have told you that pirated case. So whether we can publish same paper into other journal, because we have published that paper because that was the UGC care list, and later on because earlier, like I will speak about Mukt Shab journal. That I have published one paper in that particular journal, but recently when I have visited the UGC website, they have mentioned that pirated thing of that journal. It was not mentioned earlier when 2 years back I have published that paper in that particular journal. So same paper can I forward to the other referred journals?
All right. See, you can do anything with your work. So you can give it to anybody else, provided you have not signed an agreement with the first one saying that you assign your copyright to them. If you have not assigned your copyright to them, you have only sent your paper for publication. You can resend your paper for publication to any other. You know, just because journals write that copyright vests with us does not mean that the copyright vests with them. For copyright to vest in them, you have to sign an agreement saying that I assign my copyright to you. Like, you know, when we make question papers for university, I am the author, I am the owner. There's always a letter which I sign saying that I assign my copyright in the question paper to the university. Same is the case with the journals. Okay, so you can go ahead, publish it, provided you have not assigned your copyright to the first journal. If you've done that, then you can't republish without the permission of the first journal.
In case even if that journal is pirated, because if whether two journal can have same ISBN number.
Whatever may be the situation, if you have not signed an assignment, because then you will have to settle issues with them first, that it's pirated or not pirated or having same ISBN number or not. Okay, so you can go ahead republish your paper.
Okay, Dr. Alka, there's a question that one submitted thesis, should I take permission from the university to publish it?
You know, I will tell you that when I wrote my thesis, I had a problem with my dean and with my supervisor. So I didn't take their permission and I published my thesis, right? Yeah. They couldn't do a thing about it because I have the copyright. But thereafter, changes have occurred in the universities. In university, our university, for example, now, we enter into an agreement with the university saying that we will have to take the permission. I'll give you another example. You know, when our students submit their PhDs, there is this, when do you want to publish? They don't know what answers to give. They leave it blank and they give it to the university, and your thesis are now put in Shodh Ganga. Right? Yeah. Now there's a huge debate about Shodh Ganga, because once it is put on Shodh Ganga means that it is available to public at large.
Yes, domain, public domain.
Public at large, you automatically lose your right of publication. In the sense, you don't lose the right, but nobody will spend money to buy your publication when something is available on Shodh Ganga.
Yes.
So this is a debatable issue, but yes, this is how, after all, universities, they also have a point. They say that we are giving you a degree. So since we are giving you a degree, we have upper hand of placing it for public domain, because research is meant for maximum people to know about it. So you may be the copyright owner, but the assignment lies with us. The right lies with us to put it on the website. So I can't give a clear black and white answer for that.
Exactly. Okay, I think this should be the last question. If my business case is published in a reputed journal and the publisher has given a copy of the same to me as author, and I have signed on that copyright form, in that case, can I circulate the copy as the author of the case for discussion with my students? Or
Yes,
should
yes.
I pay and get it for
No,
the
no,
above purpose?
For the students, for your discussion, you don't need to take anybody's permission, especially after a Rameshwari photocopy case.
Yeah, but regarding the circulation of the copy of the case, I think it depends on what copyright information she has signed in the copyright. Because I
Whatever
think,
you sign, no, whatever you may have signed, irrespective.
yes.
For teaching purposes, you don't need to take anybody's permission.
No, Dr. Alka, because recently I published in Emerald and they wrote a condition that now you have to take permission for circulating it further. Educational purpose, you do it.
To educate, you're asking for students only, na?
She has asked two questions. One is for circulation on her own, and the second is for educational purpose. So educational purpose, so it's clear.
But otherwise you can't. Because
Depends
you've
on the
assigned your
subject.
copyright. That's what I said. When I wrote my book, I've assigned my copyright to them. I and you stand in the same position with respect to the book, because I don't have it right now.
Exactly. Excellent. I mean, it has been such a learning for me also, though I have been teaching, and 80% of whatever you taught right now, it's a pleasure. 70-20% of our UG students have learned through IP course.
Thank you so much.
Excellent. Very nice session. And in fact, a lot of our faculties were interested in having this session on copyright because they're facing a number of issues right now.
Thank you
So
so much.
Any more questions? Hello? I think everybody has left for lunch. It looks like nobody's asking. But
A short point.
There with you.
Hello.
We are listening to you only.
Okay. So if you have question,
Ma'am,
otherwise we'll relieve her.
Ma'am, very short one, ma'am. Just a clarification, probably I would have missed it.
Sure,
When ma'am was speaking at the start, when we are preparing for the PPT to be delivered at a particular time, so that preparation period is also exempted, ma'am?
Yes. In the course of instruction means the entire semester.
Okay, ma'am. Thank you.
But you know, Dr. Alka, in reality, it doesn't happen. I mean, the biggest violation is done in terms of copyright.
No, this I'm telling you, Delhi School of Economics people, they were making course packs. That's how the case went. So 3 publishers, Oxford and Cambridge, I don't know, and the third one, they had gone to the court, and the court has said that they don't have no copyright violation because we've got a fair dealing provision. So even we people, we do it. We make what we refer to as the case material for students. We give any article there, anything there in the case material, but it has to be for private circulation.
Yeah, that's the way we do for Harvard case studies. It goes through the authority.
Yes. You simply have to write on the top for private circulation, and you don't have to make it available for public.
Okay. Are you referring to the some DU Rageshwari court case also?
Yes,
Oxford and Cambridge, they were into some.
Yeah. So, and the third publisher, I've forgotten the name.
Okay. Wonderful.
Thank you.
I'm so thankful to Dr. Yashwant. I came to know about you through him only, and I didn't know. Yeah, I knew. I had heard a lot of places, but I didn't know you're a PhD in copyright. So perfect for being here.
Thank you.
Really nice.
Thank you for calling me.
So if all of us are done, should we say thank you to Dr. Alka very formally? I'll just wrap up saying, Dr. Alka, thank you for making it, and that also on Sunday. And the way you explain tells you about your clarity, your level of intellect in this area. This is called mastering your area. And I'm sure all the audience is fully satisfied. We look forward to connecting with you again in future. Thank you so much.
Thank you.